saying.
The broadcast is now starting. All attendees are in listen-only mode.
Okay, and hello everybody, and welcome to today's webinar, How to Protect Your Trade Secrets While Doing Business in China. My name is Philip Healy, Helpdesk Project Manager, and I will have the pleasure of being your webinar moderator today. Joining me shortly will be our expert who will take us through today's topic. Okay, so throughout the presentation, we would like you to interact with us, our speaker, by typing in your questions and comments using the question pane on your screen. We'll be answering those questions live and also after the presentation during our Q&A session. So let's take the platform for a quick spin. Let's gauge your attendance and test whether you understand how it all functions. We'd like you to all raise your hand using the raise hand option you see on the top left of your interaction tool. Right there, just where the arrow points it out. So, okay, we'll give you a quick second to respond there. Okay, looks fantastic. You seem to have all grasped the concept there. So we have around, I think, 20 attendees today, most of which are based in Europe. A few I see in China. Fantastic. Relatively small group, so that should allow for a lot of questions. So please don't hesitate to let us know if you need clarifications or if you have a problem with the platform, or if you have some key questions that relate to your business and you want to get them out nice and early. Don't hesitate to do so. We can point them out to our expert and also tackle them during the Q&A session. Okay, you can ask these questions actually directly via your mic. If you've got one, you can obviously use the question pane as I just pointed out earlier on. So one or the other, the team here in place is ready to respond and help you out with any of those questions or clarify anything. So don't hesitate to reach out. Okay, so and just to really maybe troubleshoot the usual question that we get during the webinar, yes, indeed, the recording is available after the session. It'll be available on our website a couple of days after the session, and you'll receive an email with the PowerPoint included. So no fears there. Okay, so for those of you who are not already familiar with the China IPR SME Helpdesk, we are a project funded by the European Union, and our services are free. We provide jargon-free first-line confidential advice on intellectual property issues in China to European SMEs. And as you can see on the screen, it's not only the China IPR SME Helpdesk, it's also the ASEAN IPR SME Helpdesk. The ASEAN IPR SME Helpdesk, that's quite a mouthful, caters to, does exactly the same thing as the China Helpdesk, but deals with issues regarding IP in Southeast Asia. Okay, so you can, same concept, we have both websites for both projects, we have events, we have e-learning modules, we have inquiry lines set up and materials on both projects to tackle any issues that may have occurred to you, or will you have any questions on IP questions that, IP issues that you may have encountered in either geographical locations. Okay. So maybe to give you a little bit more background, the helpline itself, you can receive a question within 5 working days, sorry. The training events are held throughout the year across Europe and China. IP materials on the China Helpdesk, deal with sector-specific issues. They deal with issues that are specific to certain IP rights, all of which you can find on our website. And if you're interested in learning a little bit more, so you can follow our blog or our newsletter by signing up on our website. Okay, So without further ado, I'd like to introduce you to today's speaker, Benjamin Bai. Benjamin, this is the first time with us. Great to have you in the office. Great to have you present with us today. It's always a pleasure working with you. Why don't you tell us a little bit about yourself so we will get to know you.
Good afternoon, good morning, and thank you, Philippe. My name is Benjamin Bai. I'm the partner in charge of IP practice for the Shanghai office of Allen and Overy. I was born and raised here in China. Then I went to the U.S. to study chemistry first. Then went to law school. I practiced the U.S. law for about 7-8 years before I returned to China. First part-time, now full-time, focusing on IP issues in China. I primarily focus on advising international companies operating in China in terms of how to protect intellectual property. And I currently have a trade secret case filed in Shanghai and also the United States. So I'm going to share some of our experience here.
Thank you, Benjamin. Fantastic. Okay, well, maybe before we get right into the presentation, what we'd like to do with you is, well, ask you a few questions. We call these polls. It's really to gauge and understand who you are, where you're coming from, what might be your issues. Very simple questions to which you can all participate. Ola's our technical director today on the webinar is launching the polls as I speak, so it should come up on your screen relatively shortly now, and you'll be able to, well, give us the answers to these two questions. And Benjamin, of course, you're more than welcome to comment here. But this first one is quite simple. Do you have any business dealings in China? Okay. So it looks like, well, I'll give you a couple of seconds there to send your votes. Looks like most of you have fired off your votes. Obviously, this is business dealings in or with China, so whether you're located in Europe or in China, that should apply. Okay, it looks like we have everybody who's voted now, or at least 90% of you, and the answers are, well, overwhelmingly, and probably unsurprisingly, we have, yes, 88% of you have business dealings with China, and 13% are planning to. So fantastic. I mean, that's a nice little spread. I mean, obviously, we'll be catering to those of you that maybe are more experienced in China, but also for those of you that have little or no experience in China, and kind of outline what's important in terms of prevention, but also in terms of enforcement. Okay, second poll. This maybe relates more so to those of you, the 88% I just referred to earlier on, but all please feel free to vote. Simple question once again is, have you experienced any trade secrets theft while operating in or with the Chinese market? So is that a yes, is that a no, or is that yes but not personally? Okay, we'll give you a few minutes there as we see the votes come in. Maybe not minutes, but a couple of seconds, yes. Okay, so, well, a more even spread here, I think. We've got 20% of you that have actually indeed experienced trade secret theft. 30% of you have not, and 50% have, yes, maybe not directly, but certainly have maybe experienced through a third party maybe some theft of trade secrets. Okay. Okay, well that's very interesting. We have a really kind of varied bunch today. That's great. What we're going to do now is, well, what I'll be doing is leaving it to Benjamin to present the rest of the presentation to you. Please feel free, as I mentioned earlier on, to ask your questions. We're here to interact with Benjamin and ask him questions on the spot, so no problem sending us your questions as early as possible. Okay, it's all yours, Benjamin.
Thank you. I think this is a very nice background. And it's interesting to know that you are already operating businesses in China or going to, and you've heard someone had trade secret issues, although you personally, most of you have not dealt with this. Let me share my in-the-trench experience here. It is possible to protect trade secrets in China. I have to say, China is probably the hardest place to protect trade secrets, looking at from a U.S. perspective or a European perspective. I think U.S., no offense to the Europeans, U.S. is the easiest place to protect trade secrets, and Europe is probably the second, and China certainly is the hardest. Okay, the reason why is because there are some evidentiary rules that really make it difficult. The concept of trade secret is very similar to the West, so that's not a problem. The problem here is there is no U.S.-style discovery in litigation or the UK-style disclosure. Of course, for those who are in continental Europe, you don't have that as well. But the judges will allow certain kind of evidence to be admissible. However, in China, copies are not admissible, so you cannot litigate. In fact, you cannot litigate any case based on copies of an original. All evidence must be original. If you don't have original, you are going to be in big trouble. So if you only got a copy from your friend who says, hey, look, I got this from a friend who works in this competitor, and they're using your drawing, guess what? This copy of drawings is not even admissible. So basically, original written evidence is practically the only form of admissible evidence in China for trade secret cases.
Just to butt in there, Benjamin, to what extent maybe could copies be notarized? Would that be admissible?
If you can find the original, then you can notarize the copy, that's okay. But if you don't have the original, then notarize, you can't.
Of course.
Yeah. Okay.
All right.
Now, going on to the definition of a trade secret, as I said, it's very similar to the West, so I'm not going to really read my slide. As you can see, it's business or technical information that's not known to the public. It must have economic value, and the trade secret owners must be doing something to protect its secrecy. Okay. So processes, methods, recipes, marketing strategies, and customer lists and pricing information can all be trade secret, provided it meets the requirement as I just described. Under Chinese law, there are two kinds of what I call actionable misappropriation. Misappropriation just means actionable misappropriation just being the act of stealing trade secret, violation of trade secret. That's just lawyer talk. There are two kinds. One is what I call perpetrator's liability, the bad actor who either acquired trade secrets illegally or disclosed trade secret illegally, or just allow trade secrets to be used by others. But there's also another aspect which is very helpful. What I call accomplice liability. Say party B is not the perpetrator, but party B helped, induced party A to violate trade secret. Then party B can also be liable. Why is this important? Think about your competitor who hires your employees away, inducing them to disclose your trade secret. Well, the employee doesn't have that much money, so even if you sue them, so what? But you can sue the new employer. So this actually is a double-edged sword, meaning if you operate in China, you have to make sure employees you hire you don't do that. You don't induce them to disclose their former employers' trade secrets, and vice versa. If your employees leave to go to a new company, you can send them a warning letter saying these technical people have my trade secrets. and please help me to protect my trade secrets. By helping me, you're helping yourself too. Now, moving on. There are several enforcement options. The first one is administrative enforcement. Even though it's available, it's not really that practical. And so I'm just going to skip. If you want to know more about it, we can talk about that during Q&A. So civil enforcement is the primary form of enforcing trade secrets. You can get damages if you can prove your loss, and you can get injunction as well. Injunction means a court order that requires the defendant to stop all bad acts, meaning stopping production or distribution of infringing products.
Thanks, Benjamin. Just a quick question there, and I think we're getting a few questions on the subject here, seeping through, thanks to Ola. I think a few of the webinar participants would like to know, well, okay, I have enforcement options, but how long does it take, and how much might it cost? Let's look at a scenario where I actually have, for example, all the evidence that you mentioned earlier on, it's notarized. I'm fine on that front, but typically how much would it cost me, and how long would it take to get damages, to get injunctive relief?
For an average case, you're looking at about 2 years on average in the first instance courts. And the cost of the litigation varies. If you go to an international firm, it'll cost you a lot more than if you went to a Chinese firm directly. If you go to a Chinese firm, you should be able to do this for less than 100,000 euro. But if you go to an international firm, it'll be a lot more than that. But of course, quality differs. And just like in Europe, you have many choices of law firms, and the very best tend to charge the most, unfortunately. All right, moving on to criminal enforcement. That's slide number 13. Certain trade secret violations become criminal. They become criminal if they cause economic loss to trade secret owners. If the loss exceeds 500,000 RMB, and that is about less than 60,000 pounds. So once they cause you that kind of economic loss, then you can go to police and ask police to start a criminal case. However, it's not that simple. First, for an average case, they're not that interested. Second is, you really have to prove there is a trade secret violation. Sometimes you need their help to investigate, because Chinese police has unlimited investigative powers. Okay, they can do a lot more things than the average lawyers or even government officials. So if they investigate, they can find a lot of misappropriation evidence. So the reason people go to police is hope the police will investigate and find evidence of trade secret violations. But if the threshold is you have to prove everything before they will help you, then it defeats the purpose. Now, I'm going to skip slide 14 because it's just the criminal code. I think, Philippe, you may have a question you want to interject?
Yes, actually we've got a few interesting questions from Gert from Belgium. And this relates to the first part of this first section when we talked about original copies and evidence. What is an original copy in this digital age?
Hello here. Thank you for your question. Interesting, very interesting question. The original of digital copy is if you have to have a Chinese notary to witness the printout of this electronic, say an email, then notarize it, that becomes the original. However, if say I sign a contract with you and we just scan the copy and throw away the original, and then you use this method to print out, that's not going to work. So if the email is created digitally, then you can print a copy. But if the evidence itself is a hard copy, then you lost it, and although you have the electronic version, that's not going to work.
So I guess that also covers, to some extent, Gert's second question, which was, is it a digital file which is notarized useful in litigation?
Absolutely, but the notarization has to happen in China. Well, if you don't, then you have to go through legalization process, which is extremely cumbersome, and also for large a number of documents, it can be expensive too, because legalization must occur in Chinese embassies or consulates. Now, turning to slide number 15, statute of limitations in China for trade secret cases is 2 years. 2 years from the time you know or should have known there is a misappropriation. Of course, sometimes misappropriation is a continuous act. If there's a continuous act, then you can always go back for the last 2 years for damages, and also in addition you can get injunction as well. So you need to keep that in mind. 2 years is the limitations period. For a single act of misappropriation, you must act within 2 years. But for continuous misappropriation, which is often the case, then really statute of limitations is irrelevant. Now, moving on to procedural remedies, or remedies for trade secret violations. There are procedural remedies, for example, evidence preservation. It's similar to, I'm going to slaughter this, CC contribution, similar to that. You can also seize property. So if you're dealing with potential defendants who may just destroy evidence or hide their assets, I highly recommend you do this. Then, of course, there's what's called the pre-suit injunction, which is in the West known as preliminary injunction. It's a court order during litigation or before litigation to ask the defendant to do something or not to do something. Of course, there's the permanent injunction, which can be granted at the end of a case. If you prevail, a court will order the defendant to permanently stop misappropriations or violations. Of course, there's compensation for damages. There are 3 criteria. You can prove your loss or their gain. If neither is available, then you can ask for reasonable royalties. Even though this sounds good on paper, in practice it's extremely difficult to do, because if, say, your trade secret is in Germany, someone took it to China, you're not really operating in China, so you don't really have lost profits. There is no discovery. Just think about litigation in Belgium or Germany and even in France. There is no discovery. You have to gather evidence in terms of their profits. If you can't gather evidence in terms of their profits, then you can't rely on that. Then reasonable royalty becomes the only one. But reasonable royalty must be evidence in China. So if there is comparable royalties in China, then the Chinese judges will look at it. You see, it's quite difficult, although on paper it looks reasonable. Now, let me explain injunctions a little bit more, just because this is critical for trade secret owners. Because if someone is about to disclose your trade secrets, what you need is to run to courts and ask for what's called a preliminary injunction, just basically a court order saying, stop, whatever you're doing, stop, and let's litigate, and then figure out who's right. The difficulty with trade secret is it's not like patents, copyrights, or trademarks. Patents are granted by government agencies. Trade secrets are not really granted by a government agency. So whether you do or do not have a valid trade secret is always going to be contested. So granting a preliminary injunction would require the court to assume the trade secret is valid. But if there's any doubt that the trade secret is not valid, then you're not going to get a preliminary injunction. And also, violations have to be very clear. In a country where there is no discovery or disclosure, how do you get evidence like that? It's very difficult. So this is why preliminary injunctions are very rare in trade secret cases in China. However, Eli Lilly and the company made history in China. They've obtained the first preliminary injunction. I'm going to call it PI. PI stands for preliminary injunction. Eli Lilly obtained the first PI in a trade secret case just about a month ago. I will spend a little bit of time later to discuss this case. Permanent injunction is normally granted once the trade secret owner prevails, but the length of the permanent injunction cannot go beyond the length of the trade secret. If the trade secret becomes public, then you won't get injunction anymore. Well, just one note. You cannot really argue in Chinese court that this former employee who went to a competitor will invariably use my trade secret. This is what the notion of inevitable disclosure. In China, you have to prove actual misappropriation, actual violation, not just by speculation. Whereas in the U.S., this doctrine of inevitable disclosure is adopted in some in some states.
Okay, thanks, Benjamin. And just before we move on to the next section, we'd like to maybe go through another poll with the audience. And this was obviously a question that relates to the second part of your presentation, where we're looking at the agreements, maybe contracts. And the idea really here is to understand whether you, the audience, have maybe signed confidentiality agreements with your business partners in China. Have you taken that step? Are you planning to take that step? Or maybe you've only done it with some or haven't at all. Let us know. We'll launch the poll shortly. And okay, well, as usual, give you a few seconds to answer that. Okay. Just a couple more. Looks like most of you have voted, and okay, 29% of you have indeed signed no, actually it's changed. 33% of you have signed confidentiality agreements. 56% of you haven't. And 11% of you have only done it with some of your partners. Okay, so that gives us a good idea of where you're at. Interestingly, maybe, Benjamin, you can tell us about maybe how crucial it is to get agreements in place and maybe the impact that will have if you don't, for example.
Well, it's critical because if you don't, then you won't be able to protect your trade secrets. So confidentiality agreement is essential, but a lot of my clients or some other companies I don't do work for, they think once I sign a confidentiality agreement, I'm good. I'm in good shape. But this is only step one. There are two more steps. Just keep in mind, I will talk about two more steps, okay? And the first step is confidentiality agreement. Also, oftentimes people forget about post-termination obligations. So if you don't specify how long the confidentiality obligation will last after the agreement terminates, And there's always this question whether forever is enforceable in China. So consider specify a definite term or have the confidentiality obligation to last as long as the information remains secret. But this is only step one to win a trade secret case. Well, a related agreement is what's called non-compete. Non-compete is an agreement to ask employee not to work for certain competitors or starting a competing business. Under Chinese law, it's absolutely legal. However, to make it enforceable, the length cannot exceed 2 years, and you must pay additional, I say, additional compensation during the non-compete period. In other words, if you ask me to stop working for a competitor for 2 years, then for every month you ask me not to do so, you have to pay me. How much do you need to pay depends on where I am in China. So local regulations govern. Normally it's between 1/3 and 2/3 of my salary. Okay. So it's very critical to have a non-compete agreement, even though this is not about protecting trade secret. However, sometimes enforcing a non-compete agreement is much more straightforward. I shouldn't say sometimes, I think it's always much more straightforward than enforcing trade secrets. And so don't forget non-compete agreement. It should be separated from the labor contract, and of course, you can only apply non-compete to senior managers, technical people, and people in that nature. You cannot apply to everyone. Of course, because you have to pay additional compensation, it's not a good idea to apply to everyone because you would be paying too much. Now, I always like to look at statistics, and the beginning of this year, we analyzed about 230 trade secret cases. Keep in mind there are not that many trade secret cases in China, so we were able to analyze 231 reported trade secret cases. It looks like the average damages award is about 20,000 pounds. The duration is, the average is 1 year. That surprises me a little bit because my personal experience is actually it's a little bit longer than that. One interesting finding is second-tier cities. When I say second-tier cities, I mean cities other than Beijing and Shanghai seem to have higher success rate. However, this is not statistically significant because there are not enough cases outside Beijing and Shanghai so that it's meaningful. For example, in one city there may be 2 trade secret cases and both plaintiffs prevailed. So that's 100% success rate that you can't not really say that's statistically significant. Only in Beijing and Shanghai do we have enough cases to say, okay, in Beijing, the win rate is about 60%. In Shanghai, it's about 46%. Don't take these numbers in the absolute, but just a trend to illustrate. In Shanghai and in Beijing, your likelihood to win lies between 40 to 60%. Okay? This is not too high, but it's not too low either. Now, more on preliminary injunctions. Why is that important? Because the civil procedure law in China got amended, and the amendment came into effect as of this year. The new civil procedure law has this broad concept called conduct preservation. It's basically preliminary injunction to preserve the status quo. Why is that important? It is important because without this civil procedure law, there is not a clear basis for courts to issue preliminary injunctions for trade secret violations or non-compete violations. Now with this broad conduct preservation under the civil procedure law, you can pretty much get preliminary injunction for anything, including trade secret violations and non-compete violations. This is why Eli Lilly was successful in getting the first preliminary injunction in trade secret case in China. If you Google this case now, you will be able to find a lot of English reports. This is about Eli Lilly's former employees, one employee, leaving Eli Lilly and taking some confidential documents with him. Eli Lilly wanted him to return the documents and he refused, so Eli Lilly sued this former employee in the Shanghai First Intermediate Court. After looking at all the evidence, the court issued a basically order to ask the defendant not to disclose or use Eli Lilly's trade secrets. This is actually an earth-shattering event because not only this is the first PI order from in China, there's actually no misappropriation yet in this case, because the guy took a bunch of confidential information. If you remember what I said about violations, just if you legally obtained confidential information but has not used for illegal purposes, then that's okay. While the court here decided to order the defendant not to basically misuse it. So I think that's really significant here. I think this is going to open the door to more preliminary injunction in trade secret cases. But I expect getting PIs will continue to be challenging even though Eli Lilly is successful. Now, the takeaway message is, operationally speaking, you want to, I like to persuade you that China protects trade secrets. It's up to you to implement a procedure to safeguard your trade secrets. Proving access to trade secret is key in China. This is the second step to a successful trade secret case. Most people know most people know to sign a confidentiality agreement. However, before you pass confidential information to a recipient, you need to ask him or her to sign acknowledgement. If you don't do that, then it'll be hard for you to prove the violators actually had access to your trade secret.
Just maybe a quick one there, Benjamin. Can you give us a few examples of just simple measures businesses can put in place to protect their trade secrets?
Yes. The easiest one is to compartmentalize your trade secrets. A lot of the information are on your company's intranet, but your intranet cannot be freely accessible by anyone. Of course, non-confidential information can be accessed by anyone, no problem, but you have to think about the level of security, password, etc., to allow people to access, but also electronically creating acknowledges as people go into confidential areas. If, say, you have a gateway saying, by clicking here, you acknowledge you will have access to the following information, and also you acknowledge you will keep it as confidential. See, that once you click that box, you go into the confidential area, and then you create electronically evidence regarding acknowledgement, basically proving of access, proving of contents, proving of obligation to keep confidential information confidential. This is easy to do now in this digital age, and I urge every company to do that. Okay, that's not enough, and some companies went to the extreme of disabling all USB drives, and you cannot copy companies' confidential information on the USB unless you get approval to do so. Then monitor all outgoing emails, and this way, and also some companies will have an alarm if certain confidential information is set outside. So electronically you can do a lot. And of course, you shouldn't do this in a secret way. You should publicize your policy to let everyone know you're watching everything. So you can foster good behavior by educating the employees, but also put in safeguards to prevent that. The most important one is what I will emphasize again and again is to obtain written acknowledgement for confidential information shared. Okay, this is very critical, and the gateways I talked about will actually achieve that purpose.
Just a quick point there. Does that need to be notarized?
When you sue, yes. As a matter of good practice, if you notarize from time to time all these records, I think it would be a good practice. I think this is sort of an overview of protecting trade secrets in China, and I think we have some time, maybe I can address some specific issues.
So yes, in terms of further reading, as you saw in the previous slide, you can have access to Benjamin's written study there, but equally you may be interested in going to our website and checking out our, and by our I mean the China IPR SME Helpdesk Guide to Protecting Your Trade Secrets in China, which outlines many of the points that we've discussed today with Benjamin. Knowing your secrets, how to keep them safe, various clauses for your contracts, what to do when your secret is out, and there are obviously a few case studies there for which you can see past experiences of other SMEs in the Chinese market. So don't hesitate to check this guide out when we'll circulate the presentation. You'll have access to that link, and if you can't wait till then you can go to our website, click on publications, and scroll down, and you'll find what you're looking for. Okay, well, we do have quite a few questions. Some of you have been quite active, some of you haven't been so much active, so please don't hesitate to send us through your questions. We've still got some time together to tackle these, so don't hesitate to do so. But let's start with maybe this first one from, once again, Gert. I think there's quite a few from Gert in Belgium, so why don't we bunch them up together? First of all, just one clarification here. It is common in Europe to transfer the content of a digital document in a so-called hash code. It is a unique code referring to the content of the document, not only the file name, but not disclosing the content itself. In the Belgian context, this can be used for notarization. Can this be done in China too?
Well, I'm not sure that's going to be substitution for notary, because evidence, if say this is done outside China, then it must be notarized and still be legalized to be useful in China. But if you can do this in China, I would still think, because it's a digital evidence, you still will have to notarize original. The Chinese courts have not gotten to the stage where they know how to handle electronic evidence. So I think they're still staying at the stage where printouts of the electronic evidence must be notarized.
Another one here. In the context of a employee leaving your company and say you haven't paid him, and however he has signed a non-compete clause, is he free at that point to join the competition?
No, actually, the preferred non-compete has this obligation, but you don't pay until you need to put them in non-compete. So that's the preferred way to do it. So you can impose non-compete on a lot of people, but selectively enforce the non-compete as they leave. Certain employees, you probably don't care, whereas others you do. So you impose the obligation up front, but then enforce them selectively. You just need to pay during the time you enforce them. That's fine.
Thank you, Benjamin. Good. If you have any questions, any other questions, don't hesitate to let me know. Okay, moving on. We have a question here from John in the UK. This refers to your slide where you demonstrated the various statistics when it came to trade secrets and how successful certain cases had been in second-tier cities. So what John says here is, given these statistics about geographical significance, where would Benjamin recommend taking a trade secret case to court? Is it first-tier cities? Is it second-tier cities?
I would still go to Beijing or Shanghai just because there are a few cases which show higher win rates in second-tier, third-tier cities. But if your trade secrets are about complex technologies, Shanghai courts and Beijing courts are much more experienced in dealing with them. And for this reason, of course, you will also be limited by jurisdiction. So this is why, with all things considered, my trade secret case was brought in the Shanghai court.
I'm guessing that made it also convenient to get back home after the day's work. Okay. Okay. Next one from Sonia in Spain. And what she tells us is, before entering into an agreement, there are usually a lot of information exchanges through email. Would you recommend to add an electronic statement under the signature to protect the contents of the email? Is that useful in China?
Yes, I think the email confidentiality notice is important. This is one piece of evidence to show that you're not treating them as non-confidential information. That's the first question the courts will ask if you go to courts and say, yeah, please protect my confidential information. If you haven't protected yourself, then the court's not going to do it. Yeah, definitely.
Okay, thank you, Benjamin. Sonia, if you have any questions to follow up, please don't hesitate to let us know. Okay, any other questions, guys? I think I have one more here. Okay, I think this might be the last one we tackle today. This is from Massimo in Italy, and okay, so I understand that by registering my patent, I will need to publish my invention for all potential copycats to see. What are the main factors I should take into account when deciding whether to protect my product with a patent or with trade secrets? Are there any other disadvantages to registering a patent rather than, for example, using trade secrets?
Yes, this is an excellent question, and this, of course, is not a China-specific question, but I have to advise clients all the time whether to protect something as a trade secret or patent it. Of course, if you patent it, you have to patent everywhere you may get copied, and it's only good for 20 years. After 20 years, and that's in the public domain, anyone can copy. So getting patented becomes very expensive. But certain technologies are not amenable to trade secret protections, particularly, say, products. Most products can be reverse engineered. I'm not saying, when it comes to products, just forget about trade secrets, but a lot of products cannot be protected by trade secrets. However, the famous product is actually Coca-Cola. Up to this day, its recipe is protected by trade secrets. Processes are much more amenable for trade secret protection. Okay, so I can't give you sort of one-size-fits-all kind of answer, but it really depends on the type of the invention, the shelf life of your invention. Say, if 20 years, that's good enough for you, I would perhaps go with a patent protection. Think about it. If Coca-Cola decided to go for patent protection, they would not have a business now. And they would only have monopoly for 20 years, and then everyone else can copy it. So not an easy question, but I hope I gave you some factors to consider.
Okay, thank you, Benjamin. And should you have any further questions, Matthew, don't hesitate. Anna from Poland has managed to squeeze her way into her quick Q&A. Maybe this is our last question here. And should you have more questions, please don't hesitate to send them. We're running out of time, but we can obviously deal with them through the help desk and let you know and give you an answer very shortly. Anyway, back to Anna from Poland. Can Benjamin give more info on non-compete clauses? Example, how long should it be paid for after the employee leaves? How much should the amount be as a percentage, of the salary?
Right. You can the non-compete period cannot be longer than 2 years. So you can obligate your employee not to work for a competitor up to 2 years. During the 2-year period, you have to pay. The percentage depends on China's local regulations. Typically, it varies from 1/3 of the monthly salary to 2/3 of the monthly salaries.
Okay, thank you, Benjamin, and Anna, I hope that answered your question. And that concludes our Q&A session. That concludes our presentation today. And should you have any questions, you still have a little bit of time on your hands to send us your questions. As I mentioned earlier on, we will deal with that through the help desk. Just a quick reminder that this presentation will be available in the coming days, and we will email you with the links and with the presentation itself. We would like to thank all the attendees again today for your time and interest in the help desk services in this presentation. We very much encourage you to use our online resources and contact the help desk for further advice should you have any additional questions, as I mentioned. You can find full details of all our future help desk webinars and events on our website under events and webinars. Thank you, Benjamin, a lot. That was a great presentation. Thank you, guys, for channeling all those questions. We'll see you very soon. But that's it from us in Beijing for today. Bye-bye.